I have a very fundamental problem with the structure of this entire bill now, especially in light of the fact that the amendments are silent on the punishments, the severity of the punishments. And you recall, because learned Attorney General, Senior Counsel Kiryowa Chiwanuka Nsumikambi, when he was giving background, he said, you've listened to the stakeholders. And one of the issues that was raised by the stakeholders was the nature of the punishments. And the amendments are very silent on them, both the custodial and the fines. Number two, Chairperson, when you look at the provisions that establish offenses, with the greatest respect, learned Attorney General, they are too broad and imprecise to be penal provisions. For example, look at page 11. I'll begin from page 10. Page 10, you say foreign policy means a policy developed by a foreigner and has not been adopted by a government. So now the question comes, what then is policy? Go to page 11. Interests of Uganda means the national interests of Uganda based on the principles of national interest and common good enshrined in the national objectives and directive principles of state policy as provided for in the Constitution, laws of Uganda, and government policy. Learned Attorney General, when I work against the interests of Uganda, I am committing an offense under this law. But you are defining interests of Uganda in a very broad manner. Very broad, very elastic. How can that be a penal provision? And how does it not really run foul to the Constitution in terms of clarity of offense? Chair, I go to political activities, again on page 11. You are in effect killing activities of political parties, in effect. Because you are saying political activities means an activity aimed at influencing the enactment of legislation, formulation of policy, or decision-making of government or the people of Uganda. And this in itself, learned Attorney General, is problematic. What is wrong with influencing enactment of legislation? What is wrong with that? What is criminal with that? What is criminal with influencing policy? Formulation of policy or decision making. What is criminal with that? Now, you are talking about under page 11, political activities. I want you to look at how you describe political activities from beginning to the end. In effect, this is a multi-party side. You are killing multipartism, political parties. In effect, when you look at this, and even in NRM will be swallowed in this in the future. So I also find your definition and description of political activities very broad, and they run counter to the spirit of multipartism. Chair, application, page 12. Wouldn't it be proper, learned Attorney General, for you to specifically state who really this act applies to? Who? Because when you are talking about the application, you give activities and the like. Who is amenable? Who is under the purview of this bill? Are NGOs involved or not? Are churches involved or not? Are mosques involved or not? In specific terms, on application. Chair, you go to page 23, clause 13, prohibition of economic sabotage. Again, an attempt by my longtime friend, the Minister for Internal Affairs, to rephrase creates a bigger problem. And I want to continue alluding to this. Learned Attorney General, this is a penal piece of legislation. Penal. And when you look at this, the impreciseness, the broadness, makes it very problematic. You are talking about a person who publishes false information. Now, who determines what is false and not? You are talking about activity that weakens. What is to weaken? What is to undermine? What is to weaken? What is to undermine?
Information.
And you are talking about economic system of viability. What are they? What are they? Realistically speaking, we are talking about a penal provision. And it is these provisions that are going to be subject of abuse, especially by law enforcement. So I would rather, Learned Attorney General, that in making these statements, let us be very specific, let us be precise. Chair, I would seek at least a comment from the Learned Attorney General. You talk about registration of an agent. Registration of an agent. What rights do I get by being registered? Because there are prohibitions here. This bill is creating prohibitions. It's creating crimes. But then there is also a requirement to register. What does it mean? If I register, do I now qualify to engage in these activities? Is that the implication? What ideally is the objective of registration? Because ideally there are prohibitions here. Crimes are being established under this piece of legislation. Finally, Chair, on page 29, declaration of sources of funding. There are two issues. Number one, on 21 and 22, Learned Attorney General. Number one, when and at what stage do I make the declaration? When and at what stage do I make the declaration? Number two, if there are, because in clause 21.1, you make reference to the Anti-Money Laundering Act. And the issues to do with declaration and source of funding, in your own view, but also in the presentations we received, are matters that can easily be covered under the Anti-Money Laundering Act. Learned Attorney General, don't you think we'll be engaging in double reporting, which in effect will be onerous for anybody receiving money, and then you are requiring them to declare under the Financial Intelligence Authority, then here under the ministry, and the like. Chair, those are my concerns as of now. I will do. But since you have compelled us, I didn't want to use the word duress, since I'll leave it at that. But I thank you, Chairperson.
Councilman, no one has. This is strictly for those who have
issues for now.
Yes.
Honorable.
Yeah. Fundraisers, mobilizers from within our country to disrupt government programs. What is your take? Because I'm not seeing any. It's what I wanted to know. Thank you.
7. Let's look at page 18 on the development of government policy. I had a particular issue, a point of concern with the proposed amendment on paragraph 4, 7.4. When you read paragraph 1, it surely demonstrates and shows that in the Constitution, government shall determine, formulate, and implement the policy of government. When you read it 2, it talks about government policy. But when you come to 4, it says an agent of a foreigner who knowingly develops and implements a government policy. Now, you have already defined the person who develops government policy. Any policy which is not developed cannot be a government policy. That is, for me, this would be a bit redundant if you look at 4. That is my one observation. Then 2, I also wanted to take you to, maybe I'd gone to paragraph 13 on page 23. When you look at, I want to look at it this way. Yes, this is a penal provision that we're developing. And in law, we appreciate that as a principle of legality, which is very clear. If you look at Article 28:12, it says, except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined and a penalty prescribed. That's very clear. But when you look at this particular provision that we are developing, it talks about an agent of a foreigner who knowingly publishes false information or participates in any act or activity that weakens. My understanding with this is that this particular aspect of this provision creates a lot of uncertainty. It creates a lot of uncertainty, and it would actually be a bit so ambiguous. It could create difficulty in the court system when they are handling offenses within this provision. I would want to draw your attention to that, to look at that particular provision. Then you go to page 28 on the certificate of registration. The certificate of registration, upon a recommendation of a department, the minister has 14 days to issue. And if he's not issuing, he has 14 days to give a reason for not to issue. If you look at 17 and 18. My concern with that, what we have done in this particular provision is to open through 18.3 that any person aggrieved by the decision of the minister may apply to court of a competent jurisdiction for legal redress in accordance with applicable law. 1, clarity ought to be put in this provision, even the court, which can be able to address this. But I'm also thinking, if we have said the minister either issues this certificate within 14 days, there are situations where the minister even keeps quiet. He has not communicated the reason why. He has not done all these things. I think we are also, in a way, creating a situation that we are telling Ugandans, go to court. Why don't we presume that while the minister remains silent upon not undertaking that activity in 14 days, let the certificate be deemed issued instead of referring Ugandans to go to the courts of law? Thank you.